Good morning, everyone. Thank you for joining us for Sterne Kessler, Goldstein & Fox's Prosecution in Light of IPR's webinar. Our speakers today are John Covert, Dr. Deborah Sterling, and Jeremiah Frueauf. John Covert is a director and the practice group leader of the firm's Biotechnology and Chemical Group. He creates patent portfolios in the life sciences and provides counseling regarding patent portfolio strategy with issues that range from licensing, collaborations, and technology acquisitions to patent validity, infringement, and design around strategies. Dr. Deborah Sterling is a director in the Biotechnology and Chemical Group. Her practice is focused in the biotechnology and pharmaceutical industries, where she is involved in all areas of patent procurement, exploitation, and enforcement. She has served as counsel on more than 40 IPRs and CBMs, including on appeal to the Federal Circuit. Jeremiah Frueauf is a director in the Biotechnology and Chemical Group. He counsels domestic and international clients on the preparation, prosecution, and defense of complex worldwide patent portfolios, as well as enforcement of those IP rights. I will now turn it to the speakers. Thank you again and enjoy the presentation.
Good morning, everyone. This is John Covert, and I will start us out with an overview and jump into some statistics. And so we're going to get to, there we go, overview. We will take a look at the numbers. We've been tracking PTAB statistics, both for IPRs and PGRs, and with a particular focus on tech centers 1600 and 1700. After that, we'll kind of talk about key takeaways, some of the lessons that have been learned from IPRs, both generally and in the biosciences. And finally, we'll talk about patent strategies to strengthen patent portfolios, some of the lessons learned from what we've seen in the early IPRs. And so this is the overall tracking of PTAB filings. And what you can see from this slide is that in the early start of IPRs, it took about 18 months to reach the 1,000 level of total petitions filed. We've kind of hit an area now where we're tracking at 120 to 140 filings per month. And so for each kind of 7 to 8 month period, that adds up to about 1,000 petitions. And so the slide demonstrates that kind of the IPRs have now become an established patent strategy, something that's thought about with respect to almost every product, every litigation, every freedom to operate where there's IP issues involved. And so how does biopharma and chemical play out in kind of the overall filings? From this slide, you can see highlighted in red that biopharma, which is probably tech center 1600 filings, accounts for 9% of the total filings. And there's an additional 6% of the filings coming through tech center 1700, which is also a chemical tech center. There are 37 IPR petitions that have been filed related to biologic products or methods of use. 14 of those appear to involve a biosimilar, either kind of product method of use or some sort of processing patent that would be involved in manufacturing a biosimilar. What we've seen so far in the ones that have had time to move through the PTAB is that 8 of these petitions have been denied institution. We have 19 petitions pending. We've received 4 final written decisions, and 6 of these IPRs have been settled or otherwise abandoned. So who's filing these IPRs and who are the patent owners that are on the receiving end? On the left, you can see the top petitioner filings, and a number of these are filed by generic pharmaceutical companies. And so 5 generic companies account for about 125 of the total petitions that we've seen in Tech Center 1600. Coalition for Affordable Drugs and Kyle Bass by themselves account for 27 more petitions. And then you can see BioReference Laboratories and Praxair Distribution kind of rounding out the list. And the BioReference Laboratories related to the BRCA1 gene patents. On the patent owner side, most of the companies listed as patent owner, not surprisingly, are marketing branded pharmaceuticals. I think Procter & Gamble is the one outlier there, and they're a consumer products company. Genentech has now kind of made this top list, and it's listed at the bottom with 10, and Genentech is primarily a life sciences biotech company, and so we're now seeing the a player that has a lot of patents and a lot of kind of core technologies protected being challenged by IPRs. Institution outcomes. We used to do this presentation, and there was a lot of talk about the patent death squad at the PTAB, and we can see a steadily declining institution rate. And on the left, it's a cumulative institution rate, and so that kind of wraps in all of the high institution numbers from early on, and the total institution rate is now kind of seems to be leveling out close to 70%. On the right side, you can see the statistics, and these institution rates are either per half or per quarter, and since second quarter of 2015. You can see that we're under 70% institution rate for that particular quarter, or for that particular quarter. At the bottom, we have it broken out. Trials been instituted for 71% of proceedings overall, and 62% of the challenged claims. And so you can see that there's a certain IPRs, not all of the challenged claims are wrapped into the proceeding, and certain of the grounds are denied at institution. In Tech Center 1600, you see a lower institution rate at 62%, 9% lower, but the challenged claims are at 57%, only 5% lower than kind of what you're seeing overall. And so, as we kind of break that down and move past the institution, now we kind of get to what's happening in final written decisions. Overall, you see the numbers on the left, and overall, 82% of claims that make it through and are instituted on are found to be unpatentable by the PTAB, and you've got 18% of the claims surviving being found to be not unpatentable. When you compare that to Tech Center 1600, you see probably less overall success rate on behalf of petitioners, and so 58% of claims are being found to be unpatentable in the Tech Center 1600 IPRs, and 42% to be not unpatentable, or to have survived. Debs, can you provide any insight as to why there's a kind of disparity between the 1600 versus overall?
Of course, John. I mean, first off, we're dealing with a smaller number of proceedings, so it's maybe it's not quite comparing apples and oranges, but they're given the difference in numbers, maybe these aren't quite the most accurate of comparisons stat-wise. But there are definitely differences that we see trends in Tech Center 1600 compared to IPRs in general. Life sciences and pharma is always considered to be a more unpredictable art, and we're dealing with very technically savvy judges here, and with the unpredictability in the art, once the experts come into play in the trial itself, we start to see a petitioner can have a harder time showing a reasonable expectation of success, for example, in an obviousness attack, once the patent owner's expert gets to put on their full case in the trial. So that's one of the reasons, reasonable expectation of success, we see the board finding issues with that in Tech Center 1600. And also, inherency is sometimes used as an attack more in Tech Center 1600 than in the mechanical arts and the like. And the board, it can be hard to prove inherency. The board really does like to, it's almost like you need to do data or have data and testing to prove that point. So it's a harder burden there on the petitioner. And because that's more relevant to Tech Center 1600 than other tech centers, that also could be adding to these statistics. And then another reason is, sometimes IPRs are filed as part of an ongoing litigation that could involve multiple, say for example in a generic scenario, multiple ANDA filers. And some ANDA filers will file an IPR and others won't, but sometimes that IPR can drive a settlement between those parties. And of course, if there's a settlement and the proceeding is terminated prior to the final written decision, then the claims would be still confirmed rather than found unpatentable. So the settlement that happens, there's settlement both pre-institution but post-institution settlement is also more common in Tech Center 1600 than in some of the other tech centers that we're seeing. So together, all of these kind of contribute to this more favorable outcome for patent owners in the pharma and biotech spaces. Back to you, John.
This is going to be our final slide on kind of numbers. And so this kind of demonstrates kind of what the preceding outcomes have been in Tech Center IPRs. And so this data is going to be 18 months prior to this month, since it takes 18 months generally for the IPR to run its course. And when you I'd like to look at the slide kind of counterclockwise when you look at the pie chart, because that kind of lines up with kind of the IPR progress, from a time standpoint. And so if you start at 12 o'clock and work counterclockwise, you see that 17%, that's 29 of the IPRs, have settled prior to institution. Moving kind of counterclockwise, 21 of the IPRs have settled post-institution. We have 10 IPRs that have ended because there was a request for an adverse judgment by the patent owner. And then you get down into the bigger slice of pie, the red slice, at 28%, and that's institution denied. So 48 IPR petitions where institution was denied. And finally, overall, see that there were 65 of the IPRs where it went to final written decision, and the final written decision was issued. So with that, we're going to wrap up those stats, and we're going to move to post-grant review. And Jeremiah.
Thanks, John. Yeah, we have just a few more numbers here, but the point is that post-grant review filings are lagging behind IPRs, which is expected given that post-grant reviews are available against patents that have an effective filing date on or after March 16, 2013. And those can either be the earliest filing date or a transition application that claims priority before March 16th, but is not entitled to a pre-March 16th filing date. So as we continue to move past that March 16, 2013 date and the pool of patent applications with effective filing dates grows, we can expect the numbers to climb here. So far, our sort of data points are coming from the IPR context, but we're starting to get some early decisions and numbers in the post-grant review context, including, so far 30 have been filed to date, including 14 in the last months. 13 of those have been filed against life science patents, with 9 of those petitions being filed in the last 6 months. So far, we have 13 institution decisions, and trial has been instituted for 11 of those proceedings, So you're looking at an institution rate of 85% overall and 78% for the challenge claims. So this is reminiscent of the numbers that John just talked to about IPRs in the very beginning. So we would probably expect those to drop as this proceeding moves forward. And just in the past month or so, the board has finally issued its first final written decision in the American Seminole case. And in that case, the issues that were part of the proceeding were 101, and there were others, but the board did institute all of the claims, and it canceled all of those claims under Section 101. And so that was our first sort of data point. And looking at who the filers are in the life science patents, we can see that So we can see that, sort of who the filers are, and it's a similar trend to some of the IPR filers in the TC 1600. A number of generics companies, and so far for the ones that have been filed in the life sciences categories, we're seeing that petitioners are challenging claims based on combinations of different statutory bases. So just as a quick reminder, PGRs are open to other bases of challenge outside of published prior art, which is limitation for IPRs. So it can include grounds such as prior art under 102, 103, just the same, but it can expand that prior art. It can have straight written description attacks, lack of enablement attacks, and as well as patent eligibility under 101, as we just mentioned with the first decisions of PGRs. And of course, priority tax can be included as well to, not only for purposes of prior art, but for purposes of trying to get a transition patent to make it patent PGR eligible. However, there are several petitions from these numbers that have included just attacks based on prior art alone, and they haven't included the other statutory categories. So we're seeing PGRs used in a number of different ways thus far in the life sciences category. Yes?
Yeah, so I'm just going to talk a little bit about what we've seen so far in, IPRs having a bigger data set than PGRs, but what do we see that leads to cancellation of claims in these proceedings, and what can you as a patent owner do about it? So first, there are some procedural issues which are basically out of your control. These proceedings are faster and cheaper than most district court litigations. So that gives an incentive to a petitioner to file, and that incentive is bolstered by the fact that there's no presumption of validity here. So the burden that the petitioner has to meet is the preponderance of evidence standard. So think more than 50% versus clear and convincing, which is up much higher in the sort of 80s, 90%. So it's a lower burden for petitioner. And the third procedural issue that makes this more favorable to a petitioner is the broadest reasonable claim interpretation standard. And recently the Federal Circuit just confirmed that that's the standard that's going to be applied here, or the Supreme Court did, sorry, after the Federal Circuit. So we're looking at broadest reasonable claim interpretation versus Phillips, and that we've seen claims construed more broadly in IPRs when in a concurrent litigation the claims are being construed more narrowly. And that extra breadth can scoop in additional prior art or just make a prior art attack stronger. The trial is conducted by a technically savvy panel of judges, and they really know patent law as well. So this can be a pro and a con if the judges will dig into the technology, and that can be to your benefit if there is a great technical distinction that you may not get a judge or a jury to understand. But on the other hand, if your argument is technically shaky as to why, say for example, broad claims should be confirmed, the board will dig into that argument. So you need to really have a good technical case here. And also procedurally, the patent owner has the ability to move to amend claims in these proceedings. It's not as straightforward as in prosecution where you amend your claims and go back to the examiner. It is a motion practice, and there are certain requirements the patent owner has to meet. And what we're finding is currently fewer than 5% of motions to amend have been granted in these proceedings. So it's really a restricted practice. Don't rely on being able to later amend claims in an IPR as a method of defense. Then there are substantively issues that are more within the patent owner's control. And these basically overly broad claims, it's really nice to have those broad claims to consider competitors or as you're developing your technology, but the broader your claims, the wider your net for prior art. And this becomes a bigger problem if you have unclear or undefined claim terms or inconsistencies in the usage, and that goes back to your patent specification. If you don't have enough detail, or you don't have, for example, a nice glossary of definitions, some patent owners are running into trouble here with how the claims are construed or how some terms used in the patent specification are being read onto prior art when a clearer specification or claim term definitions, for example, might be helpful to the patent owner there. Also, damaging boilerplate, it's common practice, it was for a long time, to cut and paste a lot of boilerplate into patent specifications just because it's company practice or attorney practice, and you want to make sure you have that standard boilerplate in there. Without much thought to that boilerplate, you can create a specification that opens your claims to more attacks, and we'll talk about this as we get into the hints and tips on prosecuting to avoid these types of substantive issues. Now, the board is less likely to be compelled by a story of the invention, unlike a jury or a judge. A jury would love to hear the story of the invention, and sometimes that's enough for them to go into the mindset that there's something patentable here. The board is less persuaded by that. They really want to know the words of the claims and the patent, what's taught in the art. But that being said, a story of the invention in the patent can help you, really start to distinguish your claims from the prior art from the outset before you even get near an IPR petition. And also, while there's no affirmative duty to search for prior art, you must, of course, put in front of the patent office all prior art that you're aware of while you're prosecuting a patent. It doesn't come with an affirmative duty to search, but if you bury your head in the sand, you may be missing some really obvious art out there that during prosecution you could craft claims around had you only been aware of it. So do some searching while you're drafting. Don't limit it. Just don't bury your head in the sand, basically. So what we've learned, basically, how can IPRs impact your preparation, your prosecution? Well, the decision to institute, it's typically based on, we said here, it's asymmetrical evidence. Up until recently, only the petitioner was able to file declaratory evidence with the petition, and the patent owner had no opportunity to file declaratory evidence prior to institution. So in that case, it was a very asymmetrical evidence prior to institution. Now the rules have changed, and the patent owner can provide declarations, but it's still likely to be an asymmetrical evidence setup. And think of a petitioner who's looking at patents and planning a challenge. The petitioner, absent any stat bar date coming up, has the time to find good experts, really develop positions, search for all the evidence. As a patent owner, you have 3 months basically from the time the petition is filed in order to put in this declaratory evidence, and sometimes that's just not enough time to gather the best evidence or get the best expert. So, and even though the patent owner can now put in declaratory evidence, the board has said that it's going to weigh that evidence in favor of the petitioner if there are disputes with the fact. So this is still going to be asymmetrical evidence going forward. And as I mentioned before, your best arguments can typically come from specified definitions in your specification rather than just general discussions of the invention. Another thing that you have to bear in mind is if you lose claims in an IPR, the patent owner, it can cast a cloud over more than that one patent in your portfolio. If you have claims of similar scope, it can become questionable whether those claims are enforceable. So you really need to consider your portfolio as a whole when you're defending an IPR. But really what this comes down to is today's talk. Getting the resilient patents in the first place is going to be your best defense against IPRs. And you really want to think of 101, 102, 103, and 112 attacks as you're drafting your patents. And particularly now with the having to be first to file, there can be a rush to get your patents on file, but you need to make sure you have that written description. Other things that we have learned generally from IPR outcomes is that if you have a lot of claims, nested claim sets, multiple patents, the fees can ultimately become a deterrent to a petitioner who may choose one or two of your patents to attack as opposed to a full portfolio, or may attack a subset of claims as opposed to the full set of claims. So these are things just generally that can be a deterrent to IPRs. With that, I think I'm handing over to John. Is that right?
All right, thank you, Deb.
You're welcome.
So now we're going to move on to strategic considerations, and there's three aspects to that. There's drafting your patent applications, there's prosecuting your applications, and then the overall portfolio building, where you're lumping the multiple applications together. And so we'll treat each of those in turn. And so we've heard this a couple times now, that the board is not constructively permitting amendments during post-grant proceedings. And we have 3 Federal Circuit decisions at this point which demonstrate the difficulty of amending, and which basically place the Federal Circuit stamp of approval on the Patent Office's approach to treating motions to amend claims in an IPR or PGR. And those decisions basically indicate that the PTO's regulations are reasonable, that the patent owner bears the burden of demonstrating that the amended claims overcome the art that's cited in the petition, but also art that's in the patent's file history as well. And so, and then the final case, Nike versus Adidas, where the Federal Circuit indicated that it's not unreasonable to require the patent owner to comply with the duty of candor and indicate that it has addressed all of the art that is known to the patent owner. And so that indicates that you've got that duty of candor that applies to this motion to amend. As a practical matter, there have been 128 motions to amend that the board has dealt with. 1 has been granted in full. That motion was unopposed, and it was a government case. 4 have been granted in part, and 2 of those 4 were in related IPRs. So that's at best a 4% success rate, including the unopposed motion. So what we've seen is many practitioners have stopped pursuing such motions as a result of this case law. That if you have a continuation pending and can file another continuation, track 1, and run amended claims through the Patent Office quickly, that's one opportunity to try to get the claims that you need in front of the Patent Office. And so this limited ability to amend in an IPR reemphasizes kind of good practices for claim drafting. I don't think these things are essentially new points. People have been doing them for years, but the role of multiple claims and a varying scope is very important in the IPRs. If you can have those patents, it makes it difficult to file a petition because the petition has to treat each of those claims. And it allows you to have claim differentiation when appropriate. It allows you to have kind of the varying scope, and it really places more of a burden on the petitioner to deal with all of those limitations, because the Patent Office looks at each of those claims, looks at the petition carefully. Don't waste your dependent claims. So think very carefully about your dependent claims and craft them for commercial value, for patentability. And again, there's more costs involved in presenting more claims, but it does increase the burden on a petitioner. If there are different statutory categories that you can draft your claims to, continue to do so. Try to comply with restriction requirements and maintain consonants in order to avoid later kind of estoppels against the patent owner, because you may have kind of patent claims that look to be patently indistinct from claims that went down in an IPR. And so the role of careful prosecution and replying to restriction requirements, maintaining consonants, calling divisionals as opposed to continuations, not only is important for avoiding obviousness type double patenting rejections, which are a huge issue, but I think we're predicting that we'll see that they will be helpful in avoiding some of the estoppels that can apply to patent owners in IPRs. As Deb's mentioned, the board construes claim terms under broadest reasonable interpretation standard, and the Supreme Court has just upheld this. We've seen petitioners, arguing broad interpretations of the claims in order to, stretch them and be able to come in with good prior art. And so, what can an applicant do? There was a tendency in the past, there were some people that had the strategy to file patent applications that were maybe malleable and could be kind of stretched and construed in many different ways later on in litigation. It behooves patent applicants now to have at least some claims that are as clear as possible under 112 second paragraph, and that have good definitions that can be construed by language in the specification that's clear. And so you need to consider this while you're drafting your applications, to have kind of strong definitions. And so back in 2014, the ZTE versus Content Guard decision was a decision where the petitioner was trying to construe claims in an IP or tech case very broadly, and the patent owner was able to refer to a glossary in the specification that had a nested set of definitions, and those definitions were very clear. Terms were defined by using the verb is, and an explicit definition was provided as opposed to it may include. And so based on those definitions in the patent application, the claim construction proposed by the petitioner was denied, and that basically saved the day for the patent owner. Prior art searching. Again, if you know the prior art ahead of time while you're drafting a patent application, it increases the odds that you'll be able to draft claims that are construed to exclude the prior art. And so knowing that art ahead of time allows you to write a patent description and specification that defines the invention in such a way that it doesn't not read on kind of the prior art that you can easily discover. And this obviously allows you to kind of point out differences create additional embodiments, draw different lines in the sand that distinguish your invention from the prior art that you're aware of. For worldwide consideration, it allows you to put the facts into your patent application that will provide a problem solution analysis for inventive step in Europe. It's not a U.S. kind of issue, but again, it always pays to know kind of what the prior art is when you're drafting the application, as opposed to trying to carve around it during prosecution, and especially trying to deal with it in an IPR where your options are very, very limited. And at this point, I'm going to turn to prosecution. I'll hand it back over to Jeremiah.
All right, thanks, John. So let's switch from drafting to prosecution strategies in view of PTO post-grant proceedings. And let's start off with secondary considerations or objective indicia of non-obviousness to rebut a prima facie case of obviousness. So far, we've seen the board rigorously evaluate the objective indicia, which can include things like commercial success, unexpectedly superior results, long-felt need, failure of others, industry praise. So just as they want the petitioner to connect each piece of evidence and arguments in the petitions, the board requires a strict nexus between the evidence and the claimed invention, that the comparison be to the closest prior art, and that the evidence be commensurate in scope with the claims. So as an example, the Federal Circuit affirmed the board's rigorous evaluation of South Alabama's evidence of commercial success in the case that's on this slide. And that's where South Alabama had offered success based on a number of drug products. And the board said, well, that was not reasonably commensurate in scope with the claims. Claims were too broad, and the Federal Circuit affirmed the board's rigorous evaluation of that evidence. And the board also closely parsed South Alabama's industry praise as focusing on an element of the claim that was already in the prior art rather than the claim as a whole. So to address the rigor, the evidence should align with the claim scope, and examiners can be somewhat less rigorous than the board sometimes, but keep in mind that we're prosecuting with an eye to these post-grant proceedings. So the goal is to obtain patents that can withstand an IPR or a PGR challenge. And to get there, you should be prepared to sell the need for generating evidence, for example, data to support unexpected results, is to sell that need to management to strategically perform experiments that support your inventions, both your foundational portfolios and downstream lifecycle portfolios as well. And be prepared to demonstrate a nexus between the claim dosing regimens, PK parameters, manufacturing process, patents, formulations, etc., and the claims, so that it is commensurate in scope and that the comparison is to the closest prior art that is raised during prosecution. And it behooves you to make sure that your evidence is rigorous where you need to introduce it during prosecution to help withstand some of the challenges that the petitioner is going to make against that evidence. So next, let's consider prosecution history arguments and the creation of estoppels, which one avoidance strategy has been to keep patent file histories lean, and that was really aimed at concerns about discovery and district court litigation. However, now that we're prosecuting with an eye towards potential post-grant challenges, the question arises that should that lean file history be revisited? Should the strategy to keep the file history lean, should we take a second look at that? And we really have some pros and cons based on the IPR decisions to date. On the pro side of creating a more developed prosecution history record, where an applicant needs to add in evidence to rebut an examiner's interpretation of the art, for example, it creates an additional hurdle for a petitioner to overcome in its petition. So such evidence can include, for example, a Rule 131 or cat swear-behind declaration to overcome pre-AIA prior art under 102A, for example, a Rule 130 prior art disqualification declaration, or a Rule 132 inventor expert declaration, for example, to argue the state of the art or commercial success. So petitioner needs to address this evidence in its petition, and in doing so, we'll need it to fit within the page and the word count limits. And again, as sort of John and Debs have alluded to, if you have a number of claims, and that also adds to the burden, these are, this would be an additional sort of hurdle that the petitioner has to consider when they're putting together their petition. And in addition, the patent owner's preliminary response, in that you can, which is of course filed before the board decides on institution, you can refer to the evidence of record, and that may be one way to help, at least in your preliminary response, to consider evidence that's already been entered, in addition to now the ability to add in additional evidence at that point. On the con side, though, the more developed a prosecution history record is, and typically the more costly it is, the issues addressed may not be those that arise in the post-grant proceeding. And of course, there may be a litigation strategy that should be considered, and particularly if the litigation is imminent. So, that may outweigh a reason to introduce the evidence, particularly if attorney argument can be sufficient during prosecution, and to preserve those best arguments during the litigation. I think, overall for the strategy, it has to be carefully weighed, the extent that you want to develop your record to other, I guess sort of stresses on your portfolio, including, imminent district court litigation and now post-grant proceeding realities. So on a related note, another strategic decision to be made when bringing in the types of declaration evidence I just referred to is, who is the expert? And ideally, we typically prefer an independent expert over someone who may be an employee of the applicant company. However, sometimes it's important or even necessary for the inventors to tell their story, particularly where an independent expert cannot, like when they need to swear behind a reference. And as just noted, evidentiary issues do not always arise at the prosecution stage, perhaps because the examiner did not raise all the issues. We've definitely seen that in our practices. Moreover, with the recent rule changes, now the patent owner has the opportunity to file a preliminary response with newly generated evidence. That really, brings in, a question of whether or not, you need to bring in an expert during prosecution. But to the extent any issues that do not arise during prosecution, so you have the opportunity to submit that evidence before the board, makes this decision on institution. And so, at least you can feel confident that you'll be able to at least get in your evidence before the board is going to consider that. However, as Deb's mentioned, that evidence is going to be weighed in favor of the petitioner. So just as an aside, sorry, I wanted to just mention that. So next slide. So the inventors, something to consider now during prosecution. So in district court, there's a doctrine of asinore estoppel, and which basically says that if an inventor or an owner of the patent rights assigns those rights to another, he or she or the company cannot then turn around and attack the validity of the assigned patent or patents. Now, this is really an equitable doctrine that was created by courts, and now the board has considered this doctrine before, and consistent with its view of this issue during inter-parties re-examinations, which of course went away in 2012 when the AIA was introduced, bringing in IPRs and PGRs. The board has held that asinore estoppel does not apply. And the board has also, in the context of IPRs, in the red line dissection decision, also said that asinore estoppel does not apply, and consistent with their previous interpretation. Thus, it may be better to have an inventor on the payroll, particularly one that has left employment, so that they can't participate in an IPR on behalf of a competitor. It's worth retaining them as consultants. Consultants don't need to be disclosed, so you can protect at least the inventor or maybe a former employee from being used by a patent challenger. However, it's also begs the question, and you should consider to the extent your assignments and other transfer agreements do not already contain sort of a no challenge to validity language that includes post-grant proceedings such as IPRs and PGRs. to consider adding such language to your contracts now to create an obligation on behalf of the inventor or the assignor to not challenge the assigned patent or patents in a post-grant proceeding. Because again, the board has said that that doctrine does not apply before the board, whereas it would apply before district courts. So switching gears a little bit to overall portfolio building strategies, as you're building your portfolio, you need to keep in mind the priority benefit, particularly as you move on from your provisional to your non-provisionals, your continuations. And as we've alluded to, the board is analyzing priority benefit of claims to determine whether patents are eligible for PGR. Just by note, post-grant reviews are limited, of course, as I mentioned before, to patents issuing from an application filed on or after March 16th, 2013. And the language of the statute says that where the challenge patent contains or contained at any time a claim to a claimed invention that has an effective filing date that is on or after March 16, 2013. So, this language has been looked at, particularly in the Nguran decision that's mentioned here. And there, the priority chain extends over a decade of continuations with identical disclosure, and the attack was really on the sufficiency of the disclosure for the issued claims where the same spec was used in each continuation. And the PTAB specifically addressed the statutory language I just referred to that contains or contained at any time a claim. And the patent owner had argued that the effective filing date analysis is not warranted at the institution stage of a PGR just because the PTAB has permitted in the context of IPRs. And the board, in response, said it's not persuaded by this argument that there is a distinction of an effective filing date analysis of a challenge patent and decision on substitution of an inter-parties review for establishing references prior art and the effective filing date analysis of a challenge patent as to whether a patent is actually PGR eligible, and you have standing to bring a challenge against that. And the patent owner also, in that case, argued it was unfair and inefficient to assess the effective filing date at the institution phase because the petitioner is permitted to present expert testimony, whereas the patent owner at that time wasn't able to. But the board said it wasn't persuaded and stated the patent owner could challenge that standing after institution. But that it reiterated sort of a concern that we had when we saw the statutory language that if a claim is pending, it contains or contained at any time, the application contained a claim that wasn't entitled to that March 16, 2013 filing date, it could be eligible for PGR. And the board has said in a couple other decisions, that the petitioner has that burden, and the relevant date for eligibility is the effective filing date of the patent and not whether a later filed amendment lacks support in the specification. So if you have a claim that was pending after March 16, 2013, but your effective filing date was before, that wouldn't make the patent PGR eligible. But of course, the board, this is the board's view, and we'll have to see what the Federal Circuit does on these issues. That generally the Federal Circuit has has been favorable to the board's implementation of the AIA in these post-grant proceedings. That really begs a good strategy, particularly for transition applications, to consider filing narrow claims at the outset. You want to increase your chance of keeping it out of a PGR. Of course, if you have a first filing date after March 16, 2013, there's no way of avoiding a PGR, but something to consider at least for your transition applications that bridge that date. And of course, as I just alluded to, the board is analyzing priority benefit of claims to determine whether intervening art can be applied in the IPR context. Again, here IPRs are limited to published prior art, and you can't challenge an IPR on grounds of lack of written description or lack of enablement. But of course, those both are a part of 112 first paragraph, and by statute under 119, 120, you have to show that your priority applications satisfy 112 first paragraph, that they have the written description, the claims have the written description, and enablement in those earlier applications. So that allows perhaps effectively a 112 lack of written description, lack of enablement challenge, but really the end result is to bring in intervening art or to make art that is maybe in one statutory class of prior art into a better statutory class. And so the board in Rackspace said that the strategy is not prohibited, and if I just wanted to note that if the 112 first paragraph issue was addressed during prosecution, that may provide a barrier to attack by the petitioner, but the board has also considered where the claim scope has differed, that the issue was still ripe for consideration in the petition, and the board instituted where the claim scope wasn't exactly the same as was addressed during prosecution. So that may beg the question of whether filing numerous continuations may open the door to an intervening prior art attack. But again, the point of having a case pending, particularly in view of these post-grant proceedings, is something you need to weigh against perhaps maybe freely filing continuations to sort of raise this issue. And that sort of last point goes into the sort of the bigger big picture question of raising obstacles to IPR and sort of what are the best practices to raising those obstacles to an IPR, a PGR petitioner. And we're seeing that really creating a patent thicket, as we sort of talked about today, to the extent possible around a product, including separate patents that have claims specifically directed to the approved product or there's other aspects of the invention, can really serve as a deterrent not only for IPRs but for PGRs. And particularly to the extent a company doesn't have the funds to challenge multiple patents, to challenge multiple claims, that can really provide a barrier. But of course, sort of the bigger fortress you build with a number of patents and overlapping claims, you're creating potential obviousness type double patenting issues, which has become quite a hot topic, particularly at the Federal Circuit, and it may truncate important PTA. As you sort of look at the interplay of PTE, PTA, and ODP.
And indeed, while ODP is not an attack that's available in IPRs and PGRs, Jeremiah, we're seeing a lot of ex-parte re-exams filed at the Patent Office just purely bringing a substantial new question of patentability based on ODP over another patent. So, don't just think of IPRs and PGRs. There are other post-grant proceedings still available, and this can be a strong attack. The Patent Office likes ODP rejections.
And as part of your strategy, of course, track ones can be very important and judicious use of reissues, particularly to deal with those the relative inability to amend claims during an IPR. And track one can quickly build up a portfolio and help you if you have a negative decision, a final written decision, to get claims that are possibly patently distinct before the estoppel would take effect once all appeals are exhausted. And so, and as I just mentioned, keeping a continuation pending enables the presentation of those claims. So it's something to consider, particularly for your important portfolios, to have something pending just in case a post-grant proceeding is filed, and to have that as a backup, because it's easier to amend in a continuing application than perhaps raising issues through reissue. And so just to sort of to summarize, we've looked at a number of IPRs, and we've tried to identify the right strategies that we should be implementing in our prosecution these days. And sort of the point is that the Patent Office is as well paying attention, and particularly the patent examiners, to these proceedings, and a number of high-level officials have made points that they really want examiners to be aware of these decisions. It's already sort of on their radar and a directive to have examiners pay attention to case law coming out of Federal Circuit, but again, also to have the examiners be aware of what the board is doing through these proceedings. And so that really reinforces that you have to prosecute your portfolios, to build your portfolios in view of the post-grant proceedings. And with that, I think if we have any questions, we can address them. We have a little bit of time left.
We have one request for slides, which we can follow up with via email after the presentation. We'd be happy to send out the slide deck.
Yeah, I believe everyone who registered will at least obtain a copy of the slides from our marketing department.
All right. Well, we want to thank you for kind of logging in today and joining us. Thank you for your attention, and we hope to be able to present another webinar in the future and keep track of these developments. So thanks and have a great day.
Thank you.